Good morning, everyone. Thank you for joining us. We're going to get started right at 9 o'clock. We will speak to you shortly. Okay, it is 9 a.m. We're going to kick this off. Good morning. My name is Ted Harris. I am with the Pennsylvania Petroleum Association. I'd like to welcome you to our monthly webinar series. We normally do this webinar the first Tuesday of the month. With vacations and scheduling this month, we pushed it back a little bit. But I would like to thank you all for joining us. I know we have some attendees that are that have regularly attended this webinar in the past, and we also have some individuals that are joining for the first time. We normally, with our webinar series, will bring in a very wide topic of subject matter experts. A lot of them are associate members of our association, like HMS Legal. Today, we also bring in different government agencies to talk about any type of regulation that might be impacting your business. But really, the goal of this is to share, content topics that you're going to be able to take back and that are timely for what you're dealing with within your business. So, from an attendee perspective, you're going to be on mute as an attendee, but we do encourage you to ask questions. And the way that you can do that is by using the question feature in GoToWebinar. Essentially, type in your question throughout the presentation here today, and as we move through the presentation, we will pause or potentially wait until the end, depending on the question, to answer it. Also, this is, we have two attorneys on with us today. These are pretty in-depth rules on the federal side that we're covering. So if there's something that you're don't feel comfortable asking in a group setting, or just something you would rather have a one-on-one conversation with, Judy and Micah are both available if that's something you want to do after the fact. So please keep that in mind. And with that being said, we're gonna kick this off. I would like to introduce our two presenters today. We have Judith Castle and Micah Busey, from HMS Legal. HMS Legal has been a longtime member of the association. Judy's been helpful on multiple dynamics with our membership, specifically on the petroleum side. She has a long history, whether it be an attorney with her firm currently or previously with ExxonMobil in the space, and certainly a subject matter expert. So they're going to be covering, there's two major federal rules that either have gone into effect or will be going into effect this year. Both of them impact not only petroleum marketers, but really pretty much any business category throughout the country. And those specifically are the FTC non-compete and the DOL overtime eligibility rule. So at this point, Judy, I would like to pass it off to you and let you get started.
Thank you, Ted. I appreciate that. And thank you to all the attendees. We appreciate you joining us this morning. As Ted mentioned, Mike and I are from HMS Legal, a law firm. And I want to talk just a moment about why we're here in front of you. Our law firm practices in the administrative law area. And what that means is we represent clients in front of government agencies on all types of fronts. Everything from any compliance with federal, state, or even local laws, regulations, and ordinances. We assist clients with everything from zoning approval for bulk plants and convenience stores to getting grants money to work on capital projects. We represent clients in front of Department of Labor, Department of Health, Department of Revenue, DEP, USTIF, all kinds of different agencies. That's the full and almost exclusive focus of our law firm. Sometimes we even take a group of clients together if they want to contest a certain regulation or law, and we've been very successful in changing and modifying and clarifying different regulations within Pennsylvania. We do practice on the state and federal level, both in the regular courts and agencies like FERC. So also, Ted had mentioned that I have a long history in the gasoline and petroleum business, working for ExxonMobil and some various other local distributors. So, and I've also owned my own gas stations at one point, though I don't own them anymore, but I am very entrenched in the oil and gas business. I feel for my clients, I understand the tough area and environment that you work in. And so we're here today to help you in any way we can. So please ask questions. This is really your presentation, not ours. We're going to go over some basics, but we're going to allow time for questions, and we hope that you feel engaged in the process. If you wouldn't mind the next slide, great. So I'm going to talk a little bit about the new ruling coming out of the Federal Trade Commission, the FTC, the non-compete. It is basically, non-competes are basically, if I can't have you, no one will. So I just want to go over some basics, and then I'll get more into the implications, and then also some suggestions on what you can do. It was passed on April 23rd, and the goal was really to promote competition. The FTC, believe that this will increase small businesses up to $8,500. It will raise workers' wages, $524 per person per year. It should lower healthcare costs, and sorry, can you raise up the slide a little bit? It will lower healthcare costs and reduce prices to consumers. About 1 in 5 workers are currently under non-compete, so that's quite a substantial amount of workers that are subject to non-compete. Next slide, please. So the actual ruling goes into effect September 4th. So we're not under it yet, but we will be very soon. And what that means is almost all existing non-competes will be unenforceable. The only ones that will be able to be enforced are any that involve a senior executive. And what a senior executive means is somebody who is paid at least $151,164 a year. But just because you pay someone that much doesn't mean that you can continue to enforce a non-compete against them. That person also has to have major policy, direction, management, or control over the main company. So for instance, if you have an employee that makes $250,000 a year because they are a great salesperson, but they have no policy control, they will not be exempt from this elimination of a non-compete. If you have an employee that makes $160,000 and they have policy control, but it's only over a department, a subdivision, a small affiliate, chances are their non-compete will still not be enforceable. So there's a lot of analysis that needs to go into who can continue to be under a non-compete come September 4th. Another aspect of this ruling is that you must, as an employer, actually notify your employees of this ruling and that their non-compete will not be enforced. That doesn't mean that all the agreements that you have with your employees that contain a non-compete will be void or null or not in effect anymore. It just means that you won't be able to enforce the non-compete. This notification has to go out to all of your employees, not just the existing ones that might be under non-compete, but any employee that you may have previously employed that is or was under a non-compete. You need to notify them as well. So you can see that's an exercise that probably needs to be done before September 4th. You don't have to put this notice out in different languages, but it might not be a bad idea if you have a multiple language type base of employees, and certain people might be more comfortable in a different language. You might want to put their notification in both English and whatever their first language is. Now, the one thing I want to also note where this is concerned is that any violations will not just be raised through FTC's investigation or their random review of your non-competes, but that individual employees will have the right to submit on that email down below any companies they think that are offending or violating this rule. So it is very likely that employees that don't get these notices, or if the non-compete is continue to be enforced against them, they will be able to self-report, and you just need to be aware of that. So next slide, please. Now, how does this new rule really apply? To whom does it apply? It applies to all your workers. That means natural people. That means that if you, let's say you buy the assets of a certain company, suppose you buy the propane assets from company ABC. Company ABC can still be under a non-compete itself. So this only applies to real people. And also, like I said previously, the previous employees are also subject to this waiver or non-enforcement of their non-competes. It applies to employees whether you paid them or not. So if you have a volunteer or an intern, those people are still subject to this waiver or this non-enforcement of a non-compete. Externs, interns, volunteers, apprentices, sole proprietors who provide services. That means independent contractors that might supply services to you. They will not be, they will not have a non-compete enforced against them. What is really a non-compete? Because we think of a non-compete as a specific separate agreement that says non-compete at the top. That's not all. There's more that's included in a non-compete, excuse me. Includes like terms and conditions of an employment contract. If you're prohibiting or penalizing or preventing in any way an employee from working after they worked for you. It also applies to an employee that wants to go out and start their own business. You can't prohibit them from doing that. Any of your company policies that an employee signs that says they can't go out and work for a competing firm will also be subject to this. One thing to note is that even if Pennsylvania would pass a law saying, we're not going to follow that, the federal ruling specifically preempts any state law that's passed. So there's not going to be relief found at the state level for passing any kind of particular contrary law. Now, that's not always the case. In fact, Mike and I have litigated cases where we have successfully argued that certain federal rules and regulations should not apply or should not preempt state law. And this is not one of them, but in other cases that may be an avenue for relief. Can we have the next slide? One of the exciting things is what's not covered by the non-compete waiver or the new ruling that makes non-competes unenforceable. Like I said before, existing senior level employees with policy control are not subject to this. So you might want to think about if there's an employee that you currently have on staff that isn't under a non-compete. You might want to put them under a non-compete if they fall into this definition, and if you can do so before September 4th. But keep in mind, no agreement is valid unless there's consideration. So if there is an employee that you feel at this juncture would best serve the company if they had a non-compete, you will have to give some type of consideration, either some kind of benefit, some kind of financial reward. It can't just be after their employee is hired that they're signing something different than what they're currently used to. Now, when you're deciding that $151,164 criteria, what goes into that is not just their base salary. You have to add to that any of the bonuses or extra commissions that they might add. The good thing is you don't have to add other perks in to get to the 151, such as, housing if you do that, or some kind of other benefit that's not monetary. Those don't count toward the 151,000 criteria. The non-compete also covers garden leave. So just because you've allowed this particular employee to stay on payroll for a period of time, even when they're not working, you cannot enforce a non-compete against those kinds of employees. Not covered are stay bonuses. So if you offer someone instead of a non-compete, you offer them incentive to stay. That's perfectly valid. You can incentivize, you just can't punish someone. Retention agreements still valid. Sale of a business, what we talked about before. If you buy the assets of a business, you can require the selling business to enter into a non-compete. It also doesn't apply to franchisees and franchisor relationships. You can still protect your intellectual property. Always you can protect your intellectual property, and we recommend that you do. If you have specific standard operating procedures, certain chemical ingredients that you employ, you should protect those in your employment agreements and disallow anyone from being able to use them if they leave your company. And you can prosecute them if they try to. If there was a cause of action, suppose you had an employee that was under a non-compete and they violated that and you're in the process of litigation, that litigation is still valid. You do not have to withdraw your litigation or give up on it. You can still prosecute those. So that's another good news on this front. Also, if you have a good faith basis for continuing to enforce the non-compete agreement, such enforcement will not be considered a violation of this law. Now, what do I mean by good faith basis? In other words, if you apply the $151,164 to a certain employee and somehow the FTC comes along and says you didn't calculate it correctly, but you had a good faith reason for how you calculated it, then your enforcement of that non-compete initially will not be considered a violation. You may not be able to enforce it in the future, but you won't have gotten yourself into trouble if you have a good faith basis for what you did. You can still have non-disclosure agreements. Those are fine for people and entities. You can require that no one discusses your confidential information, your transactions, etc. And that's an important agreement that stays in place. You can still have a customer or employee non-solicitation agreements. Those are fine. Those aren't affected by this rule. And those are the things that you can continue to do that aren't going to run you in foul of this particular ruling. Micah, if you want to change this slide. Now, I don't think that this rule is so bad. I mean, it has generated a lot of concern because a lot of employers think that the non-compete is the way to preserve their competitive environment. And I think that the rule's not so bad. That's the good news, I think, because courts have always frowned on non-competes. If there's any possible way a court can decide that your non-compete is unenforceable, they normally do. We've seen that in rulings where employees or non-competes can't be beyond 2 years for employees. They can't be beyond 50 miles around your place of business. So courts have on their own limited non-competes to begin with. They frown on them and they use every opportunity they can to make them non-enforceable. So it's an uphill battle to enforce your non-compete to begin with. It's also expensive to police and enforce. How are you really going to know if every single employee you have under a non-compete is in compliance with that non-compete? It takes a good bit of investigation, review. It costs money. And then to enforce it, like I said, the employee doesn't necessarily just abide by the non-compete or stop competing because you called them and said you're in violation of your non-compete. Many of these cases go to litigation, and as we all know, litigation can be very expensive. And you have to kind of weigh whether the non-compete is worth the expense of enforcing it. There's costs involved, as you know, in signing a non-compete. An employee may feel like they need more salary to compensate for that, or it might be a detriment to an employee who's looking to be employed by your company. So there's real costs involved with non-competes on both the initial signing as well as the enforcement. And also non-competes, a lot of times, some companies, probably not nobody that's on this call or this meeting, some companies overuse the non-competes and they try to lock down all their employees so that nobody can go to their competitor. That's really thinking about the business and not the person, and it can lead to a lot of friction in the company and a lot of disgruntled employees when they feel like they're just being punished for just trying to make a living, support their families, or just have a job. My personal opinion is that there's a lot less costly ways to achieve the same outcome. And the same outcome is that you don't want your IP, your intellectual property, walking out the door. You don't want to train your employees and then have them walk out the door and you've invested all that time and money. You don't want to pay for their education and then have them leave. Well, incentives are still fine. You can still reward your employees for staying a certain amount of time. And you can also set up dynamics where if you pay for a certain amount of education or training, that if they leave, they can leave and they can work anywhere, but they would then have to reimburse you for that expense. So those kinds of things are, I think, achieve the same underlying goal of what you're looking for with a non-compete, but they do it in a way that's not so harsh and doesn't run afoul of this particular ruling. So I would say police the matter, not the person. If what the person's really doing matters to you and you don't want them to compete, there's ways to have them not share that experience with other companies. But if the person's just working for you and you don't want him to be able to work, him or her to work for another company, there's other ways to rethink that. So next slide. A little update. There is immediate litigation. As soon as this rule was passed, there was several lawsuits filed, 2 in Texas, I believe. The one there's Ryan LLC versus the FTC, and they are looking to preliminarily enjoin this ruling. What that means is, and it was granted, the court granted that preliminary injunction. And what that means is that temporarily, while the case is being heard, the rule does not go into effect. However, this particular judge only made that ruling, that preliminary injunction, apply to the plaintiff. So it's not like, as you've heard in other cases that get filed in federal court in one state, suddenly the whole entire country is subject to that ruling. This ruling is very narrowly tailored. It's just to this case, and in fact, other cases were either held in abeyance or dismissed pending the outcome of this particular case in the North District in Texas. That case is supposed to be decided as early as August 30th. So we should get some more definitive guidance on the way the courts are going to look at this rule. I imagine that there will be some limitation on this rule since it's very, very broad, and we might see more people, employees being subject to the non-competes and companies allowed to enforce non-competes against them, or the criteria might change a little, but we will know better on August 30th. And we'll certainly update you if you want on our website, and I'll let Ted know the outcome of this or any other case that we are following. The 2 issues that this particular case brings up is whether the FTC had the authority to make this ruling. There's something called substantive rulemaking. When any government agency, whether it's Pennsylvania agencies like DEP or whether it's federal agencies like FERC, they come out with a ruling. If that ruling isn't in line with their enabling statute, the actual law that gave them the authority, then they have to, then that could be evolutive of the enabling statute, right? If they come out with a rule that would normally be a regulation and subject to a specific process to approve those regulations, many of you know in Pennsylvania, you have to go through a very specific process to get regulations approved. It's very lengthy. It's a very arduous process to make sure that regulations are completely vetted. If an agency comes out with a rule and they haven't followed those rulemaking procedures, the regulation can also be knocked down. So that is one of the issues that this particular case is grappling with. The second issue is whether the whole rule is arbitrary and capricious. That just means that it's inconsistent with their authority to do so. It's overly broad, and in this case, I would say that this rule specifically is subject to being cut down or dismissed or found not lawful based on the breadth of this entire ruling. It really encompasses everyone, almost everyone is subject to this. It's been a very, very narrow piece of people. So we look forward to that outcome, and we'll share that with you when we get that. I already talked about first to file. The one Texas case was first to file, so the other ones got held in abeyance or dismissed. So next slide, please. So what do we recommend you do at this juncture? So first of all, I think you should take an inventory of not only the non-competes that you have on file, whether they're with current employees or previous employees, but you should also take a look at your company policies and some of your other agreements that might have non-compete clauses in them, such as your non-disclosure agreements. And you will need to make a list of people that you send a notification out. You'll need to draft a notification that satisfies this particular ruling and be prepared to send it out by the due date. And you should calendar that due date because it is a violation if you don't send these notifications out in a timely manner. And again, that's September 4th. You should review your policies, determine which employees need this notice, and then comply with that notice agreement. You might also want to look at some of your other standard template agreements, whether it is NDAs or other employment agreements, to make sure that they don't run afoul of this ruling. And if you can edit them now and put those templates in place, you won't have to worry about it on an individual basis. The bottom line is, I would say, don't worry too much, relax. This rule is very specific and you do need to comply with it, but the way you comply is very 1, 2, 3. If you follow those steps, you'll be in compliance. And I would also say there's a myriad of other options you can employ in your company to achieve the same purposes without having to do non-competes. If anybody needs any help with that, sure, we'll be able to help you. But I think for the most part, internally, you'll be able to handle most of these things without too much trouble. So my presentation, I think, is at its end. But if there's any questions, I'll be happy to answer them now or at the end of the presentation altogether. And Ted, Judy.
Yeah, thanks, Judy. We did have a question, and just a reminder for anyone that joined after we kick this off, you can ask questions by typing them into GoToWebinar here. So I'm going to read this verbatim. If you have a non-compete with multiple parts, meaning non-disclosure, non-customer, or employee solicitation, are parts legal and parts illegal?
I think I heard you, Ted, that if you have an agreement that has an NDA and a non-compete, a non-solicitation, would there be parts that are legal and parts that are not legal? I would answer it this way. Your agreement is legal, but you're not allowed to enforce the non-compete part of it. And if you have a non-compete part of that, you'd still have to give that particular employee notice.
Thank you. I think that was I think you understood that right in terms of the question itself. The person that asked that, if you have a follow-up, feel free to email that to me or just add more context. But Judy, I think you answered the specific initial question.
Great.
That's all we got at the moment.
Mike, that's all you.
Okay, so I'll take over. I'm going to talk about the Department of Labor. They came out with a new overtime rule. And as you can see on the screen, it's got a pretty long name, defining and delimiting the exemptions for executive, administrative, professional, outside sales, and computer employees. As most of you probably know, that there are exemptions to having to pay employees overtime, and the title of this new rule encapsulates all of those exempted type employees. So this new rule was actually published back in April. The citation, like if you wanted to find this rule and read it for yourself, it's like 180 pages. So you may not want to do that. But if you just Google 180 FR and the number that's in the parentheses, if you just Google that whole thing in the parentheses, you'll be able to find it. This new rule, while published in April, and it was published after a notice of proposed rulemaking was issued back in 2023, and parties were provided the opportunity to provide comments to the Department of Labor, try to influence what the Department of Labor ultimately issued. And if you do actually read what was published in April, you'll see that the Department of Labor did listen to some of the comments. But what the comments say is that effective July 1st, so at the beginning of this month, 24 days ago, this new rule went into effect. And so we're going to dive into that new rule, but I think it's probably important to just have some background and to understand kind of like the stepping stones of the rule. So I'm sure as most of you or all of you know, you have the Fair Labor Standards Act, which is a law passed by Congress like more than 100 years ago, or almost 100 years ago. What this law does, and it's been updated very infrequently, but it basically sets the minimum wage, and it sets working hours. So currently, the federal working minimum wage is $7.25. The FLSA also caps a regular work week at 40 hours. So, as I'm sure you're all aware, once an employee works more than 40 hours, unless they're an exempted employee, which we'll get into, you have to pay them overtime. And so the FLSA sets overtime as being at least 1.5 times of what that employee regularly makes. So if it's $7.25 an hour, they're making, I think it's like $11.50 an hour for overtime. So that's kind of the framework, the legal framework for how this new rule, or what this new rule applies to. So what's really changed? So as the title of the rule, and as I just mentioned, there are exemptions or exceptions to having to pay employees overtime. There's 2 major exemptions. The first is the executive, administrative, professional exemption. And while the FLSA actually expressly provides for this exemption, it says the words executive, administrative, professional. What it doesn't say, but what is also included in that exemption, are outside salespeople and computer experts, basically like computer software and those type of employees. So they all fall within this exemption. There's the second exemption, which is referred to as the highly compensated employee, which is basically the same as the first exemption, the EAP exemption, except the highly compensated employee makes more money, so the test to determine whether they are exempt focuses more so on the compensation rather than their job duties. So for both of those exemptions, what this new rule proposes is increasing the salary or the total compensation that the employee receives, so that they have to make more money to be an exempt employee. Basically, what this really means is that the Department of Labor is increasing the number of employees who will be eligible for overtime pay. The third thing that this rule does is the rule as was published in April goes through this long history of how infrequently the Department of Labor comes out with these new compensation thresholds, but that these new compensation thresholds, but that because of the atmosphere, the labor market, because salaries increase, that these thresholds become outdated pretty quickly. So what this new rule intends to do is to build in an automatic mechanism where every 3 years, the total compensation metric will be increased. Supposedly it will be increased to match the then existing data to support who should be paid overtime and who shouldn't. And it makes that determination based on salary figures from across the nation. So those are the 3 major changes. They're increasing the compensation numbers for the EAP exemption and the HEC exemption, and they're also building in a mechanism where that will automatically increase or adjust every 3 years. So the EAP exemption, and this is taken straight from the regulations, and the law, the FLSA, provides that the Secretary of Labor has the power, the authority to set the parameters for who qualifies under this EAP exemption. So the Secretary gets to set the compensation level, basically. And the EAP exemption applies for anyone in a bona fide bona fide executive, administrative, or professional capacity, which also includes, again, outside sales and computer people. But there's a test that that the employee needs to meet to be considered an exempt employee. So an exempt employee is someone who the employer does not need to pay overtime to. So if the employee is paid basically the first one is the salary basis test. If the employee is paid salary, that's compensation that's not subject to variation or reduction because of the amount of work or the quality of the work, that will satisfy the first part of the EAP exemption test. The amount of salary paid must meet a minimum amount, and this is what we're talking about with this new rule. The new rule directly affects the second part of the test. So I forget the number off the top of my head, but it's on a chart in another slide. I think it's like 600 currently, or before July 1st, I think the total compensation was like $644 a week, which equated to something like $36,000. And it's jumping up into the $40,000 range. I think it's $844 a week. So it's kind of a big jump. And so that's the salary level test. And the third test is the employee that is exempt must be involved in executive, administrative, or professional duties. Now those duties are, when I think of this, I think of kind of like white collar or office work. They're not doing manual labor. They're probably sitting at a desk for most of their duties. And they're not out in the field. They're in the home office. So that's the EAP exemption. The HCE exemption is very similar to the EAP. Again, this employee, their primary duties include office work. They're not out in the field. They're not doing manual labor. But in addition to their primary duties, this employee also must perform some duty that would qualify them to be exempt under the EAP exemption. So they must be doing some administrative work, executive work, or professional work. The third and fourth parts of this test is all about the salary. So this is very similar to the salary level test in the EAP exemption. The employee has to be paid salary, but the salary must be paid. It must also meet a minimum weekly payment. So I think the next slide is the dollars. Yes. So for the EAP exemption, let's look at that first. So prior to July 1st, employees that made more than $684 per week, which equates to $35,500 roughly. If you made more than that amount of money as an employee, you are considered an exempt employee. As long as you were performing an executive, administrative, or professional outside sale or computer job duties, you were not eligible for overtime pay. Now, the new rule, as of July 1st, jumped that by nearly $200 per week. So now, only if you make more than $844 per week, which is roughly $44,000 a year, are you exempt from being paid overtime. And then there's kind of a third step up, the third step up. Starting January 1st, that's going to increase by almost $300 more per week to $1,128. So if you make more than $1,100 basically per week, beginning January 1, you will be considered an exempt employee. So the inverse of that is that if you're making less than 800, if you have an employee who is making less than $844 per week now, they're going to be eligible for overtime under this new rule. And beginning on January 1st, if the employee makes less than $1,128 per week, or $58,600 a year, they are going to be eligible for overtime pay. And then at the bottom of this chart, we have starting July 1st, 2027, under this new rule, the new compensation levels will kick in. So I think the presumption is that beginning in July of 2027, the total compensation will increase from $1,128 per week. So you'll have to make even more money as an employee to be considered an exempt employee. So so that's the EAP compensation. The HEC is basically the same, like it's the same framework. So before July 1st, if you were making less than $107,432 and you were making at least $684 per week. So what this means is you could not pay someone a minimum salary and then inflate that salary at the end of the year with bonuses to try to avoid this the HEC exemption. So they have to meet both. It's the total salary and the salary per week. July 1st, that's going to bump up to almost $133,000 and $844 per week. And the $844 per week matches the EAP compensation's weekly breakdown. And then again on January 1st, 2025, so in about 5 months, it's going to jump up to a little over $151,000 per week. Also, around $1,100 per week must be paid weekly. And again, in July of 2027, it's going to be, presumably those numbers will increase once again. So if employees are making less than $133,000 in total compensation, they may no longer be eligible for the HCE exemption. So they may be a non-exempt employee, which means they may be eligible for overtime. Sorry, I know that's confusing. So let me try to say it again. So if they make less than $133,000, they may be eligible for overtime. Okay, so that's that's the rule. That's all that's changed. So in when you look at the EAP exemption, the tricky part of that test, the 3 parts is do they have a salary? Is that salary minimum, the minimum required salary? And then what duties do they do? Well, what are their duties? That's the 3-part test. So the only thing that has changed is the minimum salary part of that test is question number 2. The tricky part in determining whether you're eligible for overtime or not is the duties part, but that hasn't changed. So if you currently have employees in your business who are exempt from overtime, that is, you're not required to pay them overtime. Their duties the only thing that you need to look at is, has their salary increased to be above the minimum threshold, the $844 per week. If they are making more than $844 per week, then they are still not eligible for overtime. However, if they are making less than $844 per week now, what you need to do Well, if they're making less, then they are considered non-exempt, which means they are eligible for overtime. So if they are making less than $844 per week, you as a business need to kind of crunch the numbers, look at your budget sheets and see if it makes financial sense to increase their salary to keep these employees as exempt employees that you do not need to pay overtime. And that's really, I mean, it's the way that this rule was issued. This is really a math question. This is a dollars and cents issue. Does it make sense for the company to keep them as exempt employees, as employees who are not eligible for overtime, or does it make sense to pay them overtime, to keep their salary where it is, and pay the 1.5 times their regular pay if they work more than 40 hours per week? Now, what needs to happen if you decide that you want to keep their salary as it is or less than the $844 per week, if they were exempt employees where you didn't have to pay them overtime, but now they are going to be non-exempt employees where you will have to pay them overtime, you're going to have to train them on your company's policies. Things like, how to keep time, because if they're a non-exempt employee, they're going to have to keep track of when they reach their 40 hours, just like all of your other non-exempt employees. You're going to have to teach them, or you're going to have to train them on, leave policies, because it's probably likely that your salaried employees have different leave policies than your hourly workers. So things like that. So and maybe this is also going to include some benefits that you offer for that non-exempt employees may have more or less benefits than your exempt employees. So those are kind of like internal paperwork, housekeeping type of issues that you're going to want to address, because this is going to be a big change for a lot of people. I think the Department of Labor, I think the rule anticipates that this is going to affect 4 million employees. And that might be for the January step up. But by January 1, at least 4 million employees are anticipated to become non-exempt employees, meaning 4 million employees will be eligible for overtime pay who were not eligible prior to July 1st of this year. So I just want to touch base on some kind of legal updates and where this thing stands. So as you can imagine, there have been legal challenges to this rule. And as you can see on this, so what I have here on this slide is the three leading cases. They were all filed in Texas. And 2 of them were filed in the Eastern District of Texas, and 1 in the Northern District. And I have their citations if you're interested and you want to try to follow these cases to completion. We will also follow them, and we can provide updates as they move along. So Secretary Sue, so in the first case, Plano Chamber of Commerce versus Sue. Sue is the Secretary of the Department of Labor. So the Chamber of Commerce is suing the Secretary of Labor who issued this new rule. And the Chamber of Commerce in this case decided that they wanted to expedite this case. They want resolution before the next step up, the next increased compensation occurs on January 1st. And the court has agreed to that. So the Chamber of Congress, or the Chamber of Commerce, unlike in the other 2 cases, the other 2 cases, the plaintiff wanted a preliminary injunction. They wanted to stop this rule immediately. But in Plano Chamber of Commerce, the chamber decided that it wanted to forego asking for a preliminary injunction, which is a lengthy and expensive part of litigation, it wanted to not seek that type of relief and instead expedite this case. So it's expected a decision will come out before January 1st. I think it's probably also expected that there will be an appeal from whoever loses this case, and that appeal would go to the Fifth Circuit. And I mentioned the Fifth Circuit because in the Fifth Circuit, the Department of Labor back in, I think it was 2019, may have been 2018, but they proposed a similar rule to what was proposed here, and the Fifth Circuit shot it down. They invalidated it, said basically what the Fifth Circuit said was that this new rule put too much emphasis on salary and did not put enough emphasis on the duties test. So that's just kind of maybe what we can expect once this case moves forward. So the second case, the state of Texas, they sued the Department of Labor and also the Secretary, and they did want a preliminary injunction. And they were actually awarded a preliminary injunction by the Eastern District of Texas. Now, the judge for the Plano Chamber of Commerce and the state of Texas case, different judges, but they sit kind of in the same judicial district. So the state of Texas as an employer, so any state employee, their employer is the state. So the state only was granted a injunction as to this new rule. So what that means is the state of Texas, there are no new employees eligible for overtime if you are an employee of the state of Texas. This judge also made the decision to consolidate this case with the Plano Chamber of Commerce case because this is basically the same thing. So it's kind of procedurally weird because there's these cases are happening in Texas, and the state of Texas, as the employer, has a preliminary injunction, but the other plaintiff does not. And I will also mention, and it's on the slide here, that the state of Texas, when they filed their lawsuit, they asked for a nationwide preliminary injunction. This court opted not to give them that relief. They limited it. So the same thing in the Flint Avenue case, which is the third one. Again, this is also a case in Texas, but in a different judicial district. So this district is not necessarily bound by what the Eastern District is doing. And in Flint Avenue, they also asked for a preliminary injunction for a nationwide preliminary injunction. It was also denied, and the court is expected to issue summary judgment before January 1 of this year, which of course, they're trying to issue the summary judgment, which is a final resolution of the case before the compensation jumps again on January 1st. So that's kind of what we're looking for. I'm not aware of cases being filed anywhere else in the nation. Texas seems to be the kind of the chosen battleground for these cases. But I think, especially, I would assume if the Democrats can hold on to the election, that no matter who wins or no matter who loses in these cases, this will be appealed. Probably this will be appealed to the Fifth Circuit and probably eventually to the Supreme Court. So for the moment, we have to abide by the new rule. You need to implement these, the new compensation thresholds, but just be on alert that this may change, and it could change pretty quickly. And we'll be monitoring these cases. We'll be providing updates. I think we'll probably post on our website blog posts that give some updates. So if you want to follow it or come to our website, if you contact us, And I have our contact information here. Ask us questions. We can let you know what's going on in these cases. So I think with that, I don't really have anything else. Ted, were there any questions that came in?
Yeah, thank you both for the presentation and your subject matter expertise. We did have 2 questions come in. I think it was, I believe, on the tail end of Judy's presentation and directed at the FTC ruling, but I'll ask them regardless and let you jump into it. So this is a 2-part question. I'll read both. Is there a standard form notice format that will be released for companies to send out? To confirm, this would be the second part, to confirm the notices only have to go to previous employees whose agreements are still in effect, correct? Question mark.
Thanks, Ted, and thanks to the person who asked the question. Yes, there is a form that you can use, and it is part of the Federal Registry publication. We'll try to send that over to you, Ted, so you can post it. And in terms of all employees that are under a non-compete must be notified. So whether they're current or past employees, as long as the non-compete is still applicable to them, they must be notified. So if you had an employee 10 years ago that is no longer under a non-compete, they don't have to be noticed. But both current and prior employees that do need to be noticed.
Thank you, Judy. That is what we've gotten in to date, or at the moment. I will give 30 seconds here for any other questions that come in. In the meantime, Judy, Micah, any kind of closing comments or final thoughts on your end?
I'll just say that Micah brought up following us on our website, and so you don't have to directly email us. You can, obviously our email addresses are right there, but our website is really simple. It's hmslegal.com. So hmslegal.com. We post regularly on there any updates to any of these type of rulings. So if you want to pop on hmslegal.com to just take a look, it doesn't cost you anything, and you can keep up to date with that. So just a helpful hint.
We did get a comment that's also a question, and I will answer it. I know the answer to this one. So the question is, well, the statement was thank you, and then the question was, will you send out notes or the presentation after this? So the answer is yes. We will send a recording of the webinar for anyone that participated today. You're more than welcome to share that with, watch it again or share it with anyone within your organization. And then Judy and Micah were kind enough to also offer the presentation as well, which will be a part of our wrap-up email. So expect that, coming here. That's automated to go out tomorrow morning at 9 a.m. So you'll get it at that point. And I would like to encourage, like I said, both their contact information is on the page here. HMS has been, as I alluded to on the front end of this presentation, has worked with numerous PPA members, ones that I'm familiar with, and then there's, I'm sure, multiple interactions that I'm not familiar with, right? So please consider using them as a resource here, whether it's these 2 topics today or their very specialized expertise within, all things petroleum. So please keep that in mind. Seeing no more comments, I think we're going to wrap up here for the day. So Judy and Micah, thank you again for the presentation and all your subject matter expertise on the topic. Thank you for everyone from our membership that participated today on these 2 very important federal rules that are going to impact your business. And please keep it in mind here as you're moving forward, whether on the association side or with companies like HMS Legal. We're here to be a resource for you as you navigate through this. So thank you all. I hope you have a great rest of the day, and take care.
Thanks.
Thanks.